Good morning and welcome to the first meeting of the committee for 2020. Can I ask that everyone make sure their mobile devices are switched off and put away? Item 1 is Stage 2 consideration of the Female Genital Mutilation Protection and Guidance Scotland Bill. And I'd ask members to refer to their copy of the bill and to the marshalled list of amendments and groupings for this item. Can I welcome Christina McKelvey, Minister for Older People and Equalities, to the meeting. Good morning, Minister. And we'll now begin our consideration of amendments. Everyone should have with them a copy of the bill as introduced, the marshalled list of amendments that was published on Monday, and the groupings of amendments, which sets out the amendments in the order in which they'll be debated. There will be one debate on each group of amendments. I will call the member who lodged the first amendment in that group to speak to and move that amendment, and to speak to all other amendments in the group. Members who have not lodged amendments in the group but who wish to speak should indicate that by catching my attention in the normal way. I would ask anyone doing so to be succinct and to make sure their contributions are relevant to the amendment or amendments being debated. And I remind members that this stage is not a rehearsal of arguments about the general principles of the bill. Members will be able to comment again on the merits or otherwise of this bill at stage 3 debate in the chamber. Standing orders give any Scottish Minister a right to speak on any amendment. I will therefore invite the Minister to contribute to the debate just before I move to the winding up speech. The debate on the group will be concluded by me inviting the member who moved the first amendment in the group to wind up. Following debate on each group, I will check whether the member who moved the first amendment in the group wishes to press it to a vote or to withdraw it. If they wish to press ahead, I will put the question on that amendment. If a member wishes to withdraw their amendment after it's been moved, they must seek the committee's agreement to do so. If any committee member objects, the committee immediately moves to the vote on the amendment. If any member does not wish to move their amendment when called, they should say not moved. Please note that any other MSP may move such an amendment. If no one moves the amendment, I will immediately call the next amendment on the marshalled list. Only committee members are allowed to vote. Voting in any division is by a show of hands, and it's important that members keep their hands clearly raised until the clerk has recorded the vote. The committee is required to indicate formally that it's considered and agreed on each section and schedule of the bill, and so I will put a question on each section at the appropriate point. Can I call Amendment 23 in the name of Oliver Mundell in a group on its own? Oliver Mundell to move and speak to Amendment 23, please.
Thank you, Convener, and subject to the guidance you've just given it, I wanted to first just make a general point about my amendments, because I think it will speed things up throughout, and that was just to say, I think at stage 2 there's always two choices. One is to try and put things that are perfect into the bill, but I also think stage 2 can be an opportunity to put things that are important into the bill and create an incentive for the government to work with members across the committee and indeed the Parliament at stage 3 to get the technical drafting correct. So subject to that point, Amendment 23 is designed to be a simple amendment to give rise to the concerns that we heard throughout evidence, and for me particularly on our visit to the multicultural family base, where a number of people we've spoken to have been concerned about, in effect, what teeth these protection orders have, and a feeling that they need to see practical support in place immediately as a result. And for me, the most important word in Amendment 23 is may. The Court may include in the protection order a requirement to provide practical support. It doesn't mean that they have to. It doesn't interfere with the responsibilities already set out. It's an additional provision, and I think that there are circumstances in which it would be appropriate for the Court to be prescriptive, to put a duty on public sector bodies, to put a duty potentially on other individuals. I think the nature of the offence and what we're trying to do here is so important that there is a public policy incentive to put this special provision in place. And I would hope that members across the committee will agree with that.
Okay. Do any other members wish to contribute? Sure, maybe.
Thank you, Convener. And I just wanted to comment briefly on this amendment, and I am minded to support the amendment. because I do think the element of support will be crucial to the success or otherwise of these protection orders, and it was something that we heard throughout the evidence sessions that the support that victims will be provided with will be crucial. The only point I will raise, and I'd be grateful perhaps if the member in winding up could clarify it, what he envisages that support would look like and who would provide that support and who would fund that support. Because the wording of the amendment could perhaps be taken to be quite broad, and I think some clarification of what he views that support to be would certainly be helpful.
Alex.
Thank you, Convener. Yes, I echo Mary Fee's comments, but also to say that I support this amendment for a number of reasons, not least because there is a symmetry here between this amendment and what happens in the children's panel system right now, the children's hearing system. It may be by definition that the people who will be subject to these orders don't have a lot of interface with the public sector or the state, and as such may miss out on opportunities for support when they are in need of that support. I think the court is, there are other examples where the court makes such provision elsewhere in law, and so I support this amendment.
Angela.
Thank you very much, Convener. I mean, I come to this with many years of frontline experience, both of going to courts and tribunals to ensure that vulnerable people do indeed get support and protection. And I know I'm not alone in this committee. There are many others with that frontline experience as well. And I certainly recognise that the motivation for this amendment certainly comes from listening to real life experience and that desire to do something in response to hearing heart-wrenching life experiences. I suppose maybe where I differ a little bit from Mr Cole-Hamilton is that I think there is a bit of a theme with this amendment and other amendments in Mr Mundell's name, where there is an attempt to cut out a separate set of arrangements for one particular set of victims. And while there are some parallels with what happens elsewhere, I think there are also some differences as well, because the important thing is that professionals on the ground, and this happens, you know, in terms of child protection orders, it happens in terms of parole reports. There are many, many examples that the information is gathered and presented to the court. This feels to me like the court is empowered to make very specific decisions that doesn't fit well with the rest of the system. And I'm also conscious that I suppose I would, you know, we want to hear from Mr Mundell more specifics about, you know, some of the stakeholder support. We got feedback from the Minister who has, you know, tried to, you know, take things forward, but there are mixed views out there. And I suppose what I'm concerned is that we end up with a bit of legislation that's not implementable and then isn't actually implemented, it becomes meaningless, or we get the worst case scenario where providers are criminalised, of course.
I'd just be interested on how the member feels that it would make the legislation unworkable when this is a standalone provision that sits in addition to what's already on the face of the bill. So I don't think it would prevent the bill doing anything it currently does. This is an additional sort of provision that would be open to the court. It's not something that they have to use. It wouldn't stop them doing anything that the government intends at the moment. It just would allow them, if they thought it was necessary. And I think our courts in Scotland are considerate. They are mindful. They are used to dealing with complex situations. I think they'd be able to balance up when it was necessary to make a specific specific obligation.
You've made a few points there that I would appreciate the opportunity to respond to, Convener. I think the 2 points that I have made is that the information and the expertise is meant to come from the ground up and not from the court system down. And I think in pursuing this course of action, if Mr Mundell wanted to see issues of more mandated support, I think there's something about a whole systems review or change across both the child protection and the adult protection system. And I would also draw his attention to Mary Fee's comment about what he actually means by practical support as well. I mean, in terms of a way forward, what I'll be keen to hear from the Minister is, I suppose, more about her specific deliberations on the practicalities of this amendment. If there is something that she is able to offer Mr Mundell, or indeed committee, in terms of improving matters, you know, taking things forward. And I'm also a wee bit concerned, having been around the houses a few times with various bits of legislation, that Stage 2, while amendments don't have to be perfect, they do have to be bottomed out and indeed be at least subject to reasonable stakeholder consultation and support. You know, do we know what the views are of the Scottish Court and Tribunal system of this, for example? But it might be that the Minister can offer a way forward that is at least helpful to committee as a whole.
Did you want to come in, Fulton? Yeah.
You know, broadly agree with what Angela Constance has said there. I do get where Oliver Mundell is coming from. I think that he has shown through this committee that he always provides thoughtful and appropriate interventions, and in this case amendments. But I do also note that the Minister has acknowledged that there is a need to expand in this area and offered to work with Oliver Mundell, and I think that's the right approach, because I think we do really need to be really careful. Like Angela, I come from a similar background as well. I worked in the child protection field for a long time, 8 years, and attended many child protection committees. I fully believe that that is the place where these decisions should be made and not the courts. I think what this amendment does is it almost draws us into a battle of who's best placed, the courts or the agencies and services who are actually working with children, young people and vulnerable adults. And I think the committee will know what side that I come down on that. And you know, and the reason for that is because workers in these fields are trained in person-centred approaches, are trained to do what. Absolutely, no problem.
I'm happy to stand corrected if I'm wrong, but my understanding from the drafting of the bill is that where it says the court, that would equally mean for child hearing it would be wherever the case was being heard. It's just the language that's used in the bill. It's not one or the other. Yeah, that is, but my worry on that is, and it brings me to the point that I was going to make, is you could be theoretically in a situation where the court is making one direction and then the professionals and agencies involved are saying, no, this isn't right because we've got to know this family, this person. I'll finish this point and then that'll be fine. And then, you know, that person's having to go back to court, and we're putting vulnerable folk potentially back through court systems. That's something I think we're trying to avoid. Happy to take that intervention.
Grateful to the member for giving way. I accept what the member says about the expertise of our stakeholders around the child, in particular around children, in terms of agencies and social work and the rest of it. But Mr Mundell's amendment explicitly says that the practical support that can be offered by the court is for the purpose of reducing any ongoing risk to that person of female genital mutilation. This is a very specific risk, and not one, I dare say, that those agencies and social work are very used to coming up against. So I think there's a very focused power here for the court.
I do understand that point, but it brings me back to my opening remarks. I think it needs to be handled very, very carefully, because I do think that, you know, the point is well made by Alex Cole-Hamilton, but I do think there could be many unintended consequences, and that's why I think the Minister's approach to work with Oliver Mundell going into stage 3, something that we can all get behind, I think would be the most sensible way forward. And I'm quite surprised to hear that Mr Mundell is considering to press this amendment, because in my first reading of it, I thought that it would be probing.
Okay. Minister, do you wish to?
Yeah, thank you very much. Good morning, committee convener. I'd like to take a wee bit of time to go through all of the the issues that are presented by this amendment, and I have a proposal too. As there are not many amendments this morning, I hope you'll indulge me to go through each part of this in relation to set out my points clearly in relation to Mr Mundell's amendments. One thing that we all want to do is make sure we're creating good, competent legislation here. I think we can all agree on the importance of supporting women and girls and their families where there is a current or future risk of FGM. It's certainly right that those who need that support should have access to it. And as you know, my entire approach to tackling FGM through our strategy, through our preventative work in communities, and through this this bill when it becomes an act, is to support vulnerable girls to ensure there is that person-centred approach that everybody has made reference to this morning. I think that you'll agree that the committee is utterly committed to that, as am I. But I cannot support this amendment as tabled due to my concerns over its effect, which I believe will have unintended consequences. These are fourfold, and I'd like to run through them all with the committee now to help you understand where my thoughts are. Firstly, the bill already allows support to be considered by the court. The explanatory notes for the bill sets out what a court might consider it appropriate to require a relevant local authority to do something under a FGM protection order. Members will remember that in my evidence session with the committee, we explored what services would maybe be needed to support those most affected. That is combined with the power the bill places upon ministers to bring forward statutory guidance, which makes it applicable to those bodies who would provide that support too. When published, the guidance will set out clear expectations of those bodies in terms of their response to women and girls at risk or who have been subject to FGM. Those steps taken together will ensure that the necessary framework is in place to ensure that women and girls can benefit from targeted and bespoke support to meet their needs, that person-centred approach that we all agree on. Oliver Mundell's amendment risks disrupting the balance, I believe, of competencies and expertise which exists between the court and the service providers. By inviting the court to do so, to do precise and directive, that could risk removing the benefits of a professional assessment of need and that tailored individual support. I think the committee agrees this is best carried out by the people who provide complex support packages on a day-to-day basis. I certainly do. And as you know, support is generally provided by a range of organisations from the public and the third sector. These organisations are unlikely to have the opportunity to make representations to the courts, and it may be that the court sets such precise conditions which an organisation is then unable to meet for various reasons. Angela Constance asked about the Courts and Tribunal Service. The Scottish Courts and Tribunal Services have indicated to us that they have concerns about to whom the order may apply and how the court could be informed as to what support might be available. It is also clear that Mr Mundell's amendment creates such a targeted requirement that is not limited to the public sector, but could capture charities and even private persons. This means there is a potential for a public or third sector body to be in breach of an order and to potentially receive criminal sanction. I'm sure none of us believe that that is the outcome that we want for anyone. Secondly, there are issues with how support is defined within the amendment, and others have picked up what the definition of practical support actually means. Practical support is not defined, and that could pose problems for the court not being guided by the bill as to the types of support it can mandate. There is a risk of a disconnect in terms of the court's order and what it thinks a person can do within its statutory powers and limits. In some cases, a court could inadvertently order something which may be impossible for a body to lawfully provide. Yeah.
I'm grateful for giving way. The Minister makes a very strong case about the potential problems of this amendment, but I take the Minister back to Oliver Mundell's original comment at the top of the meeting about the fact that sometimes the process of stage 2 is really just to signal to government the will of a committee or the will of Parliament to have something changed within the legislation, albeit subject to drafting changes or clarification either on the face of the bill or through statutory guidance. And whilst those points are very valid, I don't think they negate the presence of this amendment in this bill.
Okay, I'm coming to that very point, Mr Cohammett, so I'll answer it for you. But to continue on the point about what the courts could do, by mandating precise support in the order, this would then form part of the conditions of the order. That has a real effect. It would require repeated applications for variation or extension whenever the person's prescribed care package needed to be changed. This could result in multiple applications to court and multiple visits to court, even to bring about the most straightforward changes. Further formalising the experience and perhaps alienating those very women and girls that the order is designed to protect and support. Variations could even be sought by individuals who are not the protected person, which could unhelpfully interfere with that individual's care package. For me, that looks like there could be a varied and multitude of ways that an order could be varied or changed, and that would be multiple court appearances, which I think is not the way we want to go. While it is possible that these variations could be resisted, and we know that they can, the mere need to attend court or to acknowledge that the court will review the support package could cause further distress. And in my opinion, I believe that's exactly what would happen. An individual already vulnerable being required to repeatedly attend court for this purpose is just simply not desirable. And Alec Cohammett asked in his debate point and further to the point that he intervened on. The third issue in the amendment for me refers to reducing ongoing risk, which was a point that Mr Cohammett picked up, but does not take into account any future risk. If there is no ongoing risk but only a future risk, then the support requirement cannot be mandated. So we are not ensuring that any future risk to a girl or a woman would be taken into account. Yeah, well, it's up to the convener.
I thank the Minister for giving way, but does she not recognise that that wouldn't affect what happens under Section 4 and 5, which allow the future future risk to be considered as part of support? This is about ongoing risk, and ongoing risk is much more immediate, and I think that's what justifies the court making specific requests of people to provide something. I don't see this as being something about everyday matters. I don't see it being about something about ongoing care packages. I see this as being when the court thinks that there's something urgent and exceptional that needs to be put in place.
I would say a protection order is about protection, and that could be ongoing risk or current risk, and we have to ensure that all of that is covered within the bill, and your amendment limits that. Can I continue,
of course you can.
Convener? Fourthly, there is a real question as to the signal that the court might send to a public body should it decide to not deal with support for whatever reason within an FGM protection order. There is a possibility that the public bodies with responsibility for helping a person or family could feel that because the court was silent on the issue, so maybe they don't direct anything, that there is no need for that support to be provided, and I think that's a dangerous route to go on. As I said, Convener, I have seriously considered all of the issues in the amendment in detail and taken into account the views of the committee and the stakeholders through stage one. And keeping with what I've said in terms of the bills it's drafted, allowing some form of support to be considered by the court, but respecting the balance of competencies and expertise which exists between the court and the service providers, I will be tabling an amendment at stage 3 to expressly provide within section 5B that the courts may include a requirement in an order that requires a named public body or bodies to consider providing that support. Such a requirement would direct those with the relevant expertise to actively consider what support could be required and allow such needed input from support professionals as to the precise form that support would take. Again, that person-centred approach. Social workers and other frontline professionals are best placed to make these complex assessments of need and appropriate care, and both Fulton McGregor and Angela Constance made reference to their own professional experience here, and you know, in the view and ensuring that the individual's particular needs are addressed in those circumstances. This is not something that can be easily determined by court, I believe, who, by virtue of its role, is not intimately involved with both the family nor the appropriate forms of support that is available. This is an incredibly sensitive issue that we are facing here. As a former social work professional myself, I know the complexities of people's lives and the need to work with people as part of an ongoing relationship to design and provide a package of support that's tailored to their individual needs. I think Oliver Mundell's amendment rides roughshod over that person-centred approach we talked about earlier by giving responsibility for the details of that support to the wrong public body, the court. it shouldn't be with the court. My proposed amendment would have the advantage of avoiding almost completely any unintended criminalisation of public bodies and failing to meet the more onerous condition within Oliver Mundell's amendment, which could be impossible for some to do in some cases, whilst ensuring that support is referenced explicitly within the bill in a way that is consistent with the purposes of the bill to protect individuals and prevent FGM from happening. It would also be my intention that the statutory guidance could also spell out clearly to the public body the seriousness of the order and the steps that it should have to, in regard to complying with it. Therefore, I would urge the committee to vote against this amendment and hope that you will support my amendment at stage 3 to live within the spirit of the recommendations of the committee at stage 1.
Thank you, Minister. Oliver Mundell to wind up and then press or withdraw the amendment.
I thank the Minister for those comments, and some of them are helpful, but there is a fundamental disagreement here, and that is whether or not members think that it may be necessary on occasion for courts to put a specific measure in place. My experience as a constituency member of this Parliament is that public bodies are not always very good at following the directions of ministers. They're not always, they don't always get things perfectly right. And I do think the court is the right body to have that provision available. Courts are ultimately the guarantor of our human rights. They're responsible for making sure that things don't slip through the net. Absolutely.
Yeah, thank the member very much for taking an intervention. You're mentioning the courts and tribunal service. Oliver Mundell, and I know that other people have mentioned their role in this as well. Did you have any consultation with them before drafting this amendment? And if you did, what are their thoughts on the amendment?
I didn't have any consultation with them because I ultimately think that the job of the courts and tribunal service is to implement the laws of the Parliament and to listen to the will of MSPs. What I understand is that they're uncomfortable with it. They don't, they don't like how perhaps it's currently drafted, and they don't like, they don't necessarily like some of the sentiment. But I think in this particular case, given the very serious nature of this, given the difficulties we have getting people to come forward, given the very particular vulnerabilities of the women this affects, that I think there's a policy reason to do this.
Mr. Mundell, would you give way?
I was going to give way to the convener first.
Certainly.
Thank you. I know that you're coming at this from the position of wanting to do the best for women, and we were both at the multicultural centre. I just wonder if in winding up you'd be able to address the points around flexibility of support and of victims having to go back, because to my mind we heard from or we heard about women and girls and families that are actually quite far away from the establishment, and we heard how difficult it was for to engage in that. So I have to say that's my biggest concern, and I think if we're being person-centred, we want any support to be able to adapt to meet the needs of the women and girls. So just whenever you're...
Thank you, Convener. I think that is a legitimate concern. The first thing I would say is I think that it certainly from where I'm coming from, the court would be very unlikely to act silently. They're unlikely to just come up with provisions of their own. I envisaged certainly that they would, and I'm happy to look at the drafting and happy to look at working with the Minister on this type of amendment to include something that allows provisions for it to be varied.
Sorry, just I suppose what I'm thinking, we heard about families in quite complex situations and other forms of violence, domestic violence. It's important that as things change and improve, the support provided to them can change as it's moving along. So I'm not suggesting that that people would blindly offer a package of support without consultation. What I'm specifically asking about is as their lives change but the support still required, how that would in practical terms kind of work for the families, if you know what I mean.
So I think it's perfectly possible for measures within this to be time. I mean, the court has discretion, so it's open to the court to look at time-limited measures. But I'm also and review mechanisms. and I'm also happy to look and work with other people to come up with the thing. But what I am concerned about is when I hear the Minister talk about a different amendment at stage 3 that she's bringing forward that's only going to require public bodies to actively consider support. I don't think that's good enough. I don't think that's enough in these cases. I think what we want to see is a guarantee for people who come forward under this mechanism that very specific things could be fulfilled for them. But I'll let Angela Constantine.
I'm grateful, Mr Mundell. I wonder if you would accept that, given everything that's been discussed today and everything we've heard as a committee, that many of the problems and sensitivities that we're trying to navigate around, or the problems we're trying to solve, just can't be done in splendid isolation, and that it is not right for not just you, but for any one of us to be approaching this as if we have this solution, when actually not to downgrade your motivations or ideas or suggestions, but we're only going to land in the right place. I wonder if you would accept this, if there is good working with others. And would you consider that, given that there's an offer, the Minister's going to, come back at stage 3, that there's still an opportunity for you to protect your position by not moving your amendment today. You can come back with the same or similar or better amendment at stage 3, as well as the Ministers. That this feels like you're trying to do your best, but I'm concerned it's in splendid isolation. And I wonder, moving forward, how are you going to work with others to get support for the right solution based on the evidence of what's actually going to work?
Well, I thank the member for that advice, but I feel in my time in the Parliament, certainly my experience of working with the government is that you get far more support when it comes to technical drafting and exploring ideas and points of view if you've already got something on the face of the bill. And if I was interested in just preserving my own position, I would have accepted a handout amendment from the government for stage 3, and you'll be coming here today to see this as a probing amendment. But for me, there's a point of principle at play, and that is that I think the court should not must or not has to in every single circumstance, but should be able to put specific measures in place for a very vulnerable group of women. I accept that the drafting may not be perfect, but I'm not tied to the wording that's here. Yeah.
Intervention. Can you cite evidence of what you propose is actually going to work?
I think that it's easy to see how something like this could work. I think that although notwithstanding the issues the conveners raise, I don't think that there are any major issues in this. I think the court will easily understand what this is meant to be, even if it wasn't changed. But I think it could be changed and improved, and it would be possible to add in a provision allowing for that to be done by regulation and guidance. But I think that it is, it's difficult to see why members are so resistant to the court being able to put specific provisions in place when we all know that public bodies don't always move quickly and don't always get the right support in place. And I would see this applying to things like housing and the provision of some aspects of medical support and assistance, for example, counselling or advice. And certainly my experience broadly across some very serious issues, and I'm not that are as serious as this, is that things don't always move quickly for people once they're in the system, even where courts have placed general obligations on public bodies. I think it's important that they have the power in limited circumstances to make very specific requirements of public bodies to support people. I can do if the convener is happy for me to do that.
Yeah, I think thank the member for the intervention. But I think you're raising an issue about what public bodies do and don't do generally. But it seems as what Angela Constance was saying, you're doing this, Mr Mundell, off your own back. It's not what we've heard at committee. It's not what my own experience of that is. And I think that it is a wee bit disingenuous to some extent, and I know that's not your intention. I fully know that's not your intention, to the child protection agencies and services working with children and vulnerable adults who are out there doing that job. And you've acknowledged yourself that you've not spoken to the Scottish Courts and Tribunal Service, but are of the understanding that they wouldn't be happy with the amendment, but yet you're pushing on with it. This does seem to be, and don't take this the wrong way, but it does seem to be this is Oliver Mundell's view, and Oliver Mundell's view only. And, you know, I find that if we'd heard more evidence around it, perhaps it would be a different situation, but we didn't.
I understand that the member's got a different view to me on the amendment, but I certainly recall during evidence sessions the provision of support being a very real concern for people, and it appears within the minutes of meetings that were held, Convener. I mean,
Just briefly, I suppose I absolutely acknowledge that the support that women and girls need is absolutely central. But I just come back to my concern that that support needs to be centred around them. And I think with the cultural sensitivities, with the environment that the women and girls are likely to be in, that are needing protection from FGM, that the people best placed to decide that package are the specialist third sector and charity organisations that we heard from, and professionals on the ground rather than the courts. And I think that's key for me.
Thank you, Convener. Reflecting about taking an intervention from Mr. Cole-Hamilton.
I'm very grateful for Mr. Mundell taking yet another intervention. I absolutely hear what the convener's just said, and I accept that absolutely. However, I think it doesn't speak to the immediacy that this amendment refers, that if we are giving somebody a protection order, and that means there is a real and present threat that they will be taken somewhere and mutilated, and this speaks to that immediacy. Sometimes these bodies can't operate at that speed. They can't put support in place, or they can't assess in that timescale. I think that giving the court this power, and it is a power, not a duty, that it will cover that as well. I mean,
sorry, that's an intervention on intervention.
Yeah,
would you mind if I made a brief comment on that?
I'm reflecting carefully on Mr. Cole-Hamilton's comments and willing to take another intervention from the
I suppose all I would say is that what Mr. Cole-Hamilton's just said there is that the organisations, the specialist organisations, the third sector and charity that are working with women and girls day in and day out might not have the ability to act quickly. So if we're putting a legal duty on them to do so, how does that help them act more quickly? Does that surely not risk punishing them?
I think I would answer that by saying that where legal duties exist and where people could, as the Minister said, be held responsible for failing to deliver on a court order, then they're usually much more inclined to act quickly, and it can cut out some of the bureaucracy. And that's why the law, I think, is there. I think it's its most important role when it comes to ensuring that people's rights are upheld. And I think that's why people within within the courts and tribunal system, recognise that this is is an amendment that changes the status quo, and that might be, that might require them to make changes. But I think they're positive ones, and I hope that members will feel able to support me and to work with me to get drafting help from the government to make sure that the concerns that have been raised today are taken into account, but that we guarantee that debating a specific duty or power for the court to make specific provisions does make it into the final bill. And I push the amendment in my name.
The question is that Amendment 23 be agreed to. Are we all agreed? Yes. No. We're not all agreed. We'll go to a vote. Those in favour of Amendment 23, please. Those against Amendment 23? And there are no abstentions. There are 4 votes for Amendment 23, 3 votes against Amendment 23 is carried. I call Amendment 24 in the name of Oliver Mundell in a group on its own. Oliver Mundell to move and speak to Amendment 24, please.
Thank you, Convener. Amendment 24 is designed as a belt and braces amendment to ensure on the face of the bill that we see regulations made to ensure that at least a basic level of legal advice is available to people who are considering applying to the court for an FGM protection order. I've excluded from that public sector bodies, the police and the Lord Advocate, who I think should be able to access the relevant advice. So it's really looking at members of the public who would be coming forward. And I understand that the Minister has since written to the committee, but that letter, as I think everyone would accept, arrived quite late in the day, so there wasn't a huge amount of time for detailed sort of consultation around this. But what I would say is, notwithstanding what's actually said in the letter, I don't think that there's any harm in putting this provision in, because I think it still allows for the general rules of legal aid to be updated. This just ensures that regardless of what happens with that there would be advice in those very specific circumstances. And for the avoidance of doubt, as set out at 5B, which is the only reason this amendment's allowed in, because otherwise it would be likely out of scope. It doesn't interfere with any other legal aid provisions that might or might not be made. Yeah, I was just about to finish, but you could take it as an intervention.
I just wondered, when you were drafting this amendment, what consideration you'd given to the wider work that's ongoing to reform the legal aid system, and again, if you could specifically, give us a flavour about who you've engaged or consulted with, or who else, and perhaps among stakeholders, is supporting your endeavours to do.
I think that in answer to the first point, I'm aware that there's ongoing work around legal aid, but there's pretty much always ongoing work around legal aid. It's a difficult system for the government to operate. It's not an easy thing to deliver in practice across the country, across a whole wide range of areas. But again, like with my previous amendment, I think that there is a special case given that we're trying to encourage people to come forward and use this protection order to have this additional provision as a backup. Again, this was a point that tries to take forward concerns that were raised in evidence with the committee, where people are concerned about how easy it would be to access legal advice and support. But again, if there are specific concerns with the wording of it, I'm open to look at that. But again, I think that we'll find that this debate's a difference again of substance, where the government will say we're already doing this, don't worry about it, there are no problems here, and I take the view that it's better to guarantee that there would be specific provisions for this very limited set of circumstances, and to have that on the face of the bill. And again, if the government have a different idea and can bring forward something that would satisfy members ahead of stage 3, that gives us the detail, then this can come back out of the bill, or something else can be put on the face of it. But I think it's important for people who want to bring forward an application for a protection order to be able to access advice before doing that.
Okay, can I invite any other members who wish to speak? Angela and Fulton.
I mean, I suppose just once again, I heard Mr Mundell use the phrase special cases. And there is indeed some uniqueness around FGM, undoubtedly. But I'm also very conscious that there are many victims and survivors of horrendous violence, of horrendous sexual violence, and that carving out, for understandable reasons, a different set of arrangements for one set of survivors as opposed to another, I think is problematic. And I suppose I would reiterate what I've said earlier, that if people want to see wholesale change, I think it's wholesale change that's required, particularly when it comes to our legal system or the legal aid system. And also, I've not heard, if there are any other stakeholders, specifically supportive of Mr Mundell's amendment. I accept he's nonetheless got the right as an MSP to pursue it, but also about specific engagement that he's undertaken with others around the specific detail of his amendment, and that, may be something he'll address when he's making his closing remarks.
Fulton.
Thanks, Convener. Again, actually, very similar. I mean, I do see exactly where Oliver Mundell's coming from with this particular amendment. We did hear evidence. There was concerns about legal aid during the course of committee. So I don't necessarily disagree with the principle of it. In fact, I think every committee member agreed when we heard the evidence that the people who women and girls who are going through this should get legal aid if they need it. But also I didn't hear any suggestion from anyone at any time that they wouldn't get that. And I note the Minister's remarks. I just have got the same concerns as Angela Constance. I sit in the Justice Committee as well. As members know, I know that Oliver Mundell did previously. Legal aid, something that comes up across the board. We were dealing with the Vulnerable Witnesses Bill fairly recently as well, and heard some harrowing accounts there. I think what I would have quite liked is to be able to do as a committee, almost speak with one voice in terms of the inputting into the debate around legal aid reform, rather than something specific in this legislation. And I would again ask Oliver Mundell to consider not pushing the amendment just now, and working with the government and indeed all of us going into stage 3 and have a really collaborative approach about how we can get the right message across. But I do share the same concerns as Angela Constance on the wholesale change for one specific.
Okay, Mary.
Convener, the process of applying for legal aid is not a simple, straightforward thing to do, and it doesn't happen on the day you turn up and say, I need legal advice and I need legal aid. It doesn't happen that day. We're talking about a small number of people who are very, very vulnerable, are in a very, very difficult position. And I welcome the comments that Oliver Mundell made when he was speaking about the belt and braces approach. And this is about ensuring that a group of very, very vulnerable people have almost immediate access to legal advice and support at the point that they need it, not after they've gone through a process of applying, filling in forms and waiting to get a response from the Legal Aid Board to say, yes, you can get legal aid, or no, you can't get legal aid, which can take 3 weeks, 4 weeks, sometimes longer than that. So it's about providing that immediate support for people that are in desperate measures and really need it there and then. And it was something that was raised in evidence on a number of occasions, that people required or felt they would need access to legal advice. And for that reason, I am minded to support the amendment in Oliver Mundell's name.
Okay. Minister.
Oh, thank you very much, Convener. I think we'll all agree that access to justice is something that we particularly want for the most marginalised and powerless in our society, and it is a central tenet of our legal system. It's all something I think we're incredibly proud of. I understand from speaking to Oliver Mundell that his amendment is about establishing a bespoke service for individuals seeking an FGM protection order, and the effect of this amendment is to require Scottish Government to make regulations for that to happen. It's unfortunate that his amendment does not actually say that, and so focuses solely on legal advice. Firstly, we already have a system in Scotland where individuals can seek support for accessing legal advice. It's called legal aid. As I said at committee in November, the Independent Strategic Review of Legal Aid, Rethinking Legal Aid, published in 2018, highlighted that Scotland's current legal aid spend is the third highest per head in the European Union. In Scotland, about 75% of people are financially eligible for some form of legal aid, compared to only about 25% in the rest of the UK. We think that we have a robust system Given that individuals as well as local authorities can apply for protection orders, we think we have the right measure of support and understanding, and I suspect that people will get the support they need to take forward a case. While it may be the case that bespoke services are needed in England and Wales, the Scottish legal aid system is more expansive and better funded. We in Scotland do not need a parallel system for the provision of advice. As I set out in my response to the committee as part of future funding arrangements for work tackling violence against women and girls, I will include an explicit call for bids from which focus on providing a specialist initial point of contact for individuals who are seeking to apply for an FGM protection order, to work with stakeholders, to raise awareness within the communities, and to work with public bodies to ensure they are aware of the availabilities of orders and their role in potentially seeking them. Particularly for public bodies, this work will inform and connect to the statutory guidance to be made by ministers under the bill, which will bring all of that work together in the one place. Thirdly, and most importantly here, and it's something that Mary Fee raised in her comments there, I said I was committed to ensuring automatic legally for special urgency is extended to FGM protection orders. We do not need an amendment to this bill. In order to do that, we already have the powers to make legal aid available for FGM protection orders through secondary legislation under the Legal Aid Scotland Act 1986. I said I would update the committee ahead of stage 3, and I'm happy to do that now. Happy to do that now on this issue. I can confirm that we will add FGM protection orders to regulations, and this will ensure that those seeking FGM protection orders will get access to legal aid. Doing so will have the effect of ensuring that anyone applying for the FGM protection order with the grounds to do so would have automatic access to civil legal aid for the purposes of making an urgent application. And I would hope that would answer some of the questions that Mary Fee. It would apply to all types of applications, including interim orders and for applications to vary or discharge an order, provided, of course, that the matter was actually urgent. We expect that in cases where an individual themselves, as opposed to a public body, listed body, is legitimately applying for an FGM protection order, will have a particular degree of urgency. I think we all agree that these cases are likely to all be urgent. So this means that the individual would have access to legal aid at the very point of application. So no waiting for weeks on end, as some fear. Therefore, I believe that Oliver Mundell's amendment is unnecessary, as we are already ensuring that there will be ample access to legal aid for those who need it. So that Oliver Mundell is proposing, in my opinion, is not efficient and an efficient use of resources. In addition, I think there are issues with the amendment as drafted, so that it does not necessarily achieve the intended purpose. Yeah.
Sorry, just could you expand? I'm grateful for the Minister for giving way. Could you expand on what you mean by that you don't think Oliver Mundell's efficient use of resources? What resources are you referring to there?
No, I don't think it's efficient use of resources to have a bespoke parallel service, as opposed to people having the access to the legal aid as an urgent case. I was hoping we'd remedied that. The amendment... Yeah.
I thank the Minister for giving way, but given that it will be for Scottish ministers to make the regulations for the arrangements, then it's open to Scottish ministers to think about what that was. And I did not say that I wanted a bespoke service. Instead, in fact, I said that there could be an ad hoc provision and support within an existing service. And I don't know why the Scottish Government wouldn't want to make that a permanent feature of the support around this bill.
When we had a conversation yesterday, I explicitly asked Mr Mundell in the conversation we had yesterday, are you talking about a bespoke point of contact type service? And he said yes. So if that's a different position from yesterday, this is...
The Minister want to give way. I think that maybe our recollections are slightly different. I said that I envisaged that there would be a bespoke point of contact on FGM as a result of this bill, and that person would be able to help individuals access ad hoc legal advice. That's not the same as creating a bespoke legal advice service. And I think the two are slightly different.
I'll be have to disagree on that, because I think what you're asking for is a specific service, when I actually think our legal aid functions and regulations, and the new regulation which I will make will address all of those issues. The other, sorry? Yeah.
Do you mind taking an intervention?
No.
Just so that we're all clear about the facts, and I think you did say this, but I think I just want to keep us on track on the real important issue. Did you give a timescale for bringing forward regulations?
So after stage one, when you asked me to go away and look at how we can make sure that we provide for urgency and regulations and FGM protection orders to be available for legal aid, I went away and worked with my counterpart, Minister Ash Denham, on the work that needed to be taken forward to do that. So we explored a few ways to do that. We realised that actually the regulations and the power currently sat with the ministers to apply that to the current legal aid regulations. We've instructed that work to be started now, so that will come into force and into play when we need it to in future with this bill, in parallel with this bill, so that the legal aid is available at the time the bill is enacted. So, yeah.
Point of intervention. So that power that you and Ms Denham have instructed will come into play parallel when this bill comes into force. Is that the plan?
The plan and the timescale is to have the SSI in place for commencement of this bill, so that they come in at the same time.
Thank you.
Yes. No, I did think about all of that and not having it staggered. Yeah. The other issue I've got around about Mr Mundell's amendment is it's only limited to arrangements for advice for persons at risk of FGM or who have had FGM, whereas we want to consider an expansive and system-wide approach that can also include the parents or guardians, for instance, of those at risk, or which can deal with some unexpected issues. This amendment would cut across Ministers' general power to do so, limiting our ability to provide a wraparound solution. I would therefore ask Oliver Mundell to consider withdrawing his amendment, as what I am proposing above meets the intention of Oliver Mundell's amendment about providing legal aid without enshrining provisions in legislation in a way that could unnecessarily complicate matters in the middle of a significant review of the legal aid system, because we took that into account when we instructed the work on the regulations too. Thank you.
Okay, thank you, Minister. Oliver Mundell to wind up and press or withdraw.
Thank you, Convener. I'd make a couple of points in relation to what was raised in the debate. Firstly, I'd say for me that I have no issue with making specific changes in relation to specific bills. I think that it's a false argument that comes up far too often in this Parliament, that it's too difficult to put bespoke provisions in place for individual offences, and indeed we've just heard from the Minister a firm commitment to put a bespoke arrangement in place in this very case. So it's an odd argument to say that you can't make bespoke provisions because they're too problematic. My heart goes out to all victims of sexual offences and of all crime for that matter. But I think the idea that you can't change things for one group without changing things for everyone at once is not the correct. I won't at this point. Is not the correct policy approach. I think it's better to look at each act and actually, as we see that often the law, as law professors are fond to say, is like a ship at sea where the planks change one at a time. You don't try and dismantle the whole ship. And I think that the provisions we've heard from the Minister are very welcome. In terms of what she said, my only concern would be around limiting the advice to urgent cases. I think within the bureaucracy, there's always a risk that one person's urgent is not another's. And I think that I would ask her to reflect on whether it's possible to look at providing automatic legal risk where legal aid where people identify a risk. Rather than making it urgent, where there's an identified risk, and look at risk as the deciding factor, not urgency, because for the individuals concerned, every case will be urgent, and the one time that they come and ask for legal aid might be the only time, and having to wait might mean that they don't take the matter forward. So I would ask the Minister to reflect on that ahead of stage 3, because I think we've heard all these bold statements about legal aid in Scotland, and the system it is good and it does work for some people, but I think given the fact we've got a major review ongoing, we'd be kidding ourselves if we say that it works perfectly every time. So I think lowering the threshold for that automatic right when doing something as serious as this would be welcome.
I just wondered if Mr Mundell would accept that the Minister has made an on-record commitment to doing, not what I asked for, actually what you asked for. I know you've welcomed it, but I wonder if you'll take, you know, some heart and comfort of the real practical commitment made by the Minister today.
Naturally I do, and I'm pleased that the Minister has responded to the concerns the whole committee has raised. But I equally don't think that that excludes me from asking for a little bit more ahead of stage 3, because I'm certainly not asking for it for myself. I think that it's about the threshold for when that automatic provision kicks in, and that's the purpose of regulations going through the Parliament. You know, again, is for them to be subject to scrutiny, and I think that there's a strong case for lowering the threshold, and I want to put that on record myself. But I do thank the Minister for the action, and I don't intend to push this amendment today.
Okay, can I ask that the committee are content that the amendment's withdrawn? Okay. I call Amendment 1 in the name of the Minister, grouped with Amendments 2, 3 and 18. Minister, to move Amendment 1 and speak to all amendments in the group, please.
Thank you very much, Convener. Amendments 1, 2, 3 and 18 are technical in nature. They are to provide that local authorities have the power to apply directly for an FGM protection order in cases where the order will cover a class or description of persons as opposed to an individual person, and to allow a local authority to use their local court for an application in such cases. As the committee knows, the bill allows for an FGM protection order to prevent and protect in relation to an individual, a protected person, as named in the bill, and it also allows for protections for any person falling within a particular description. This could be, for example, a local community or faith group whose members may be at risk. We have sought to use these amendments to put beyond any doubt that a local authority can intervene in this way, recognise the importance of these matters being dealt with locally and person-centred, and also to amend the bill to ensure that a local authority can submit an application to their local sheriff court. And I move Amendment 1 and all amendments in that group.
Thank you. Do any members wish to comment? Okay, the question is that Amendment 1 be agreed. Are we all agreed? Agreed. Amendment 1 is agreed. I call Amendment 25 in the name of Oliver Mundell in a group on its own. Oliver Mundell to move and speak to Amendment 25, please.
Thank you, Convener. I had thought that this was the most substantive and probably controversial and complicated of my amendments, although the other two have maybe called that into question. It's certainly the one with the most drafting issues. But what I would say to members is I did engage with the Chamber Desk and took their advice on how to give voice to the policy intent, and I'm certainly open, and in fact I can give the commitment myself today that even if the government don't want to work with me if it passes, I would certainly be making some changes myself to ensure that this amendment only applies to the protected person or the person protected by the order, and it includes a provision for public and other relevant bodies to share such information as is necessary with other people in order to ensure that support or other aspects of the order can be fulfilled. But in substance, I think it's very important that we get anonymity onto the face of the bill at stage 2 to give the opportunity to the government to work with members of the committee and the Parliament to come up with a workable provision. I was convinced by evidence that we heard that there was something extra that needed to be done here. I think that blanket anonymity wouldn't be the right approach, but I certainly think that the person at the centre of the protection order and those whose lives would be intimately affected by it should have the expectation that a court will grant them anonymity and take reasonable measures to ensure that their identity and their personal information does not make it into the public domain. The government didn't bring forward this provision and said that it was it had a mixed response from stakeholders, but I think 75% of people who responded to the government consultation agreed with it, and notably the Law Society and the Human Rights Commission felt that it was necessary to do something in this area and would be helpful. I think that people should have the right, and I think that you know, unless there really are exceptional circumstances, because otherwise I think we're going to struggle to get people to come forward and use these orders.
Okay, Alex.
Thank you, Convener. Subject to the assurances that Mr Mundell has just given the committee about drafting, I'm minded to support this amendment. Ideologically, I'm in favour of more anonymity for victims generally across the board, and I said as much in my stage 1 debate, and I believe you actually intervened on me on that point, Convener, and you made a fair point to say that, you know, this is a much bigger discussion than just the specifics of this one bill. But there is no proposal before this Parliament on an anonymity for victims of crime generally. So as such, we must take incremental opportunities to extend that anonymity where we find it. And this is one such case. And I think if there is any kind of crime or potential crime that might be inflicted on a person of such intimacy and such privacy, then it is this. And as such, I think this is a good place to start. If we're to extend the reach of anonymity for victims or potential victims, then this is a robust amendment subject to the drafting changes that Oliver Mundell has already committed to, and I support it.
Okay. Fulton.
Thanks, Convener. Just a very brief couple of points to make. I think that, as others have reflected, we did hear mixed views on the committee on anonymity, and I think that both sides of the debate had very good arguments. And actually, you've already given the notes at the start, not to rehash the general principles of the bill, but we really could go through those all day, to and fro. And I think that a lot of members reflected actually that, you heard one argument, thought, no, there's a lot of sense here, and then the other. But I actually think in terms of this specific amendment that Oliver Mundell's put down today, he's made his own argument in his opening speech. He has said that there is a lot of work to be done in it. And for me, I don't think that we, as a responsible committee and responsible MSPs, can put this forward just now when it could lead to the risk. I mean, it's all right having commitments that, we're going to change X, Y and Z at stage 3, but where there's a risk that perpetrators or potential perpetrators could be subject, could get the anonymity as well, I don't feel that we can go forward. I'm open to the issue of anonymity. I think all the committee is, but I would like to see something more substantial that would only protect the individual at stage 3, and I had actually more to say, but to be honest, I think that Oliver's actually made his own argument when he said that he understands there's more to be done here, because I know that Oliver Mundell doesn't want unintended consequences of this, and my question to him would be, why press it today?
Okay, Mary, you were wanting to come in.
Thank you, Convener, and I will be very brief because many of the points that I would have made have already been made by Alex Cole-Hamilton, and Oliver Mundell gave a very full explanation of the reasoning for his amendment, and I fully accept that there are concerns around unintended consequences. But I come back to the point that was made by Oliver Mundell about the number of people in response to the consultation who said that there should be a provision for anonymity. It was something that we heard throughout our evidence sessions about protecting victims. 75% who responded to the consultation agreed that the bill should provide for anonymity, and they felt that it would enhance the dignity of victims and encourage reporting. And surely that is what this bill should do. It should protect victims' dignity, but it should also encourage people to report this crime.
Angela.
I'll be uncharacteristically brief, Convener. I mean, Mr Mundell, honestly acknowledged that, this is the amendment that needs the most work done on. And I would only point to the fact that you don't need a messy stage 2 amendment to get commitments from the Minister as a stepping stone to the best way forward or the best resting place for the solution. No, I'm going to be brief. I think it's really important that depending on what the Minister says by way of explanation and any commitments moving forward, that those, it's important to acknowledge that those are on the record commitments, and sometimes that's the better path as opposed to, you know, quite a kind of complex amendment. And I'll just leave it there.
Okay. Before I bring the Minister in, I would just wish to say that it's the issue which you highlighted yourself, Oliver, around the potential for perpetrators to receive anonymity. Now, there may well be a debate about whether perpetrators of sexual or accused perpetrators of sexual violence should be anonymous, but I'm really uncomfortable with that, and that for me, obviously there's the bit about anonymity for victims of all crime and how helpful or otherwise that would be, but I accept the points that people are making about where we make changes in that. Minister, I wonder if we've heard in evidence as well that victims can already receive anonymity, but for me it would be helpful to hear how that actually works from the perspective of a victim. What actually happens? What can the court do already to protect their identity?
Yeah. Yep. I'm happy to go to my comments on it and answer the question as we go along, Convener, if that's okay with you. I would hope again that you would give me a wee bit of time to set out my thoughts on this amendment, because I've given it a lot of thought, believe me, and I hope by doing so I would convey my deep concern about this amendment as well. It concerns my bill team, and it has, and I expressed it my concern to Mr Mundell yesterday, so I would want to make sure that the committee were fully aware of my concerns this morning. We all know that individuals may wish to be made anonymous for a number of reasons, whether it be from a media coverage, protection from an abusive partner, or fear of retribution. The needs of the person who is seeking protection from harm will always be at the heart of everything I do, and that is unshakable. So let me be absolutely clear right now, this is not about people not having anonymity or in any way expressing that I am against anonymity. Absolutely not. It's about making laws that do not run counter to the Scottish justice system and the trust that we currently place in our courts. My argument has always been that the courts already have powers at their disposal to make an order of anonymity when they take them seriously, and they are very well capable of exercising that power to do so. I want to make my argument first, if you don't mind. Therefore, whilst I believe that the long amendment put forward by Mr Mundell is unnecessary, the reason I am opposed to it and would strongly urge the committee to vote against it is that I believe, if passed, it would be very damaging. And I'll go on to explain that. When this amendment was published, the Scottish Courts and Tribunal Service contacted my officials immediately to express their concerns by saying that this amendment is unworkable. In particular, they noted that the blanket approach would cause problems for authorities and third sector. Providing support as anonymity would mean that they could not advise someone subject to the order to the public body providing the support. That seems very ironic, considering we have heard that this is what Mr Mundell wants the courts to be prescriptive with in their support in Amendment 23. So that cuts across that. This amendment steps clearly, in my opinion, over the boundary of being overtly intrusive and could produce outcomes which are not expected. Whilst I appreciate that the amendment provides that discretion may exist in exceptional circumstances, it is not in any way clear what such exceptional circumstances would actually be. The amendment provides that any person affected by the order could apply for anonymity, any person, and I am deeply concerned that this also covers perpetrators or potential perpetrators, and the court would have no real position to refuse that request. Of course, the court currently has the power to anonymise a parent perpetrator if not doing so would identify the victim. However, with this amendment, even where revealing the identity of the perpetrator would play no part in revealing the identity of the victim, the perpetrator could rely on the provision to demand anonymity. Protecting the perpetrator is not an outcome that I can ever support in any case. This runs counter to one of the key innovations we have made in this bill, which is the introduction of FGM protection orders are solely perpetrator-focused, therefore reducing risk. This amendment would apply there, also allowing a perpetrator to demand anonymity where there is no victim. This is just absolutely unacceptable. In addition to the I want to continue this argument because it's incredibly important. In addition, the amendment is prescriptively focused on applications by protected persons or those who have permission of the court. Therefore, does not apply to applications by local authorities, the police or even the Lord Advocate, which I find is a glaring omission in this amendment, and it's probably one of the reasons why Oliver Mundell himself agrees that it needs work. These outcomes, particularly in relation to a suggestion that the court is obliged to grant anonymity to a perpetrator or potential perpetrator of FGM, are something that I'm sure none of us would want to pass into law. We want all to ensure we deliver open and accessible justice, so we need to apply that in a consistent approach to do that. This amendment suffers also from a lack of foresight in terms of the complexities which have to be considered by the court. For example, how long would anonymity last for? What are the precise limits? Can it be applied for when an order is varied? Can it be applied for when an order is extended? What happens to anonymity when the order is just discharged? Can a decision not to grant anonymity be appealed? And can the court grant anonymity on its own initiative? All of these questions, as far as I can see, have not been given sufficient consideration or answers. And I know that Mr Mundell may say that he will fix all of this at stage 3, but this amendment is fundamentally flawed, damaging, and does not need amended. It needs not to be part of Scottish law. In approaching the task of making laws parliamentarians, we need to take serious care to avoid unintended consequences. By inserting this untried and untested approach, we simply do not know from this amendment the answer to the questions that I have just posed, and neither does Mr Mundell, which is a real worry too. This was not a recommendation of the committee convener, as you know. It has been done without any consultation, never mind agreement with the Scottish courts, and it seems of stakeholders too. Such consequences could potentially cause harm to vulnerable girls. And many people in the contributions there raised the issues about the people who replied to the consultation. Can I just draw your attention to the responses from one individual and one person representing a group. Dr Emma Jackson, who works in this field every day of the week, said communities welcome the Scottish Government not bringing forward legislation on anonymity of victims. And Jan MacLeod, who is a Women's Support Project, said, on anonymity, our view was that it is not helpful to pick out FGM when we do not have similar legislation about child sexual abuse, incest, rape or sexual assault. These are very compelling arguments from people who work in this field every single day of the week. So for me, passing this amendment would send a message that from Parliament to our courts and our justice system that the current broad suite of powers that the courts have at their disposal is insufficient for the purposes of granting anonymity. I know that the convener herself made this point well during the Stage 1 debate, saying that if it was an issue that should be considered across the justice system, like Jan MacLeod has suggested, then a whole justice system approach should be taken and not through this protection order bill, a point that was positively acknowledged by the Deputy Convener in his comments too. Finally, presiding officer, well, you are for purposes of this, convener, I'd go back to my central point. It is acknowledged at the highest level through judgments of the Court of Session and the Supreme Court that courts are already bound to withhold a person's identity in circumstances where the person faces a threat to life or limb, and further that they will do so where it is in the interests of justice to protect a party to proceedings from painful and humiliating disclosure of personal information where there is absolutely no public interest in doing so. This is particularly so when there is a threat that a person will not proceed with a case where there is a risk of such disclosure. FGM falls squarely into that category of case where both these examples of court powers and duties are fully engaged. I would draw committee's attention to a specific case, HMA versus Molla in 2007, which concerned the use of the power to anonymise the alleged victim of someone who was accused of deliberately infecting that victim with HIV. There, the court set out its justification for both clearing the court, using its powers, and then going on to prohibit reporting of identifying details through the existing power of the Contempt of Court Act 1981. This is a practical example of the court exercising its existing and well-acknowledged powers. In addition to the range of inherent common law powers, there are also clear and specific statutory protections in place for both adults and children to support the courts in protecting and supporting vulnerable persons and preventing disclosure of their identities. I have already provided the committee with a detailed information on that point. It is vital, convener, that courts in discharging their functions apply the law, but they should have discretion to consider all of the particular facts and circumstances in coming to that decision. They can choose who is made anonymous, and that can already include parents where necessary to protect that child. They can also choose who is bound by anonymity, allowing some information to be passed to key people involved in welfare and protection to allow them to get that support that you all supported in Amendment 23. This amendment means courts would no longer have a choice in how they provide for anonymity in such cases. This means that perpetrators will be able to demand anonymity even where there is no victim identified or where the victim is far removed from them. It also risks limiting the court's ability to share information with key people, possibly risking the support available to victims and their families, something I don't think any of us want to see. This could undermine our wider public bodies' actions in countering this hidden and pernicious crime. Oliver Mundell asks us in Amendment 23 to trust the courts. He asked us to do that, but not to trust the courts in this case, which I think is a bit of a dichotomy that I just can't understand on where he's coming from on this. So as you can see, Convener, I'm very strongly against this amendment and its consequences, and I would strongly urge the committee to vote against the damaging amendment as it stands.
Okay. Well, I'm going to move to Oliver and he may... Okay. Oliver Mundell to wind up and press or withdraw Amendment 25.
Thank you, Convener. I'm going to be pressing the amendment because I think we've heard the government appears to be strongly opposed not just to the content of the amendment but the principle of as close to an automatic right to anonymity for victims as is possible for FGM for a variety of reasons. And my own feeling is that if it doesn't make it onto the face of the bill, notwithstanding the very serious issues with it, then there'll be absolutely no incentive for the government to help me come up with something that's technically sound, that sorts out those issues. And I'll take an intervention.
For the member for giving way. And in respect of what we've just heard from the Minister as well about her concerns about the unintended consequences over the right of anonymity for perpetrators, does the member agree that we've now heard from all parties represented on the committee that there is no will of Parliament to see that go forward, and that will be resoundingly amended at stage 3 should it be passed this morning? Does he also agree that actually when the Minister said that the amendment was not subject to consultation, that amendments at stage 2 are never subject to consultation, and actually this is in response to the 75% of people who felt that there should be anonymity extended through this Act, and also that where the Minister cited stakeholder groups who said that we shouldn't be extending this provision now when it isn't extended in other areas of child sexual abuse or exploitation or other things like that, or incest or rape, as she described, that actually those of us who want to see anonymity extended to those groups who've been waiting for a wholesale change to the law and have not seen that be forthcoming, would like to use this as an incremental amendment in terms of leading change, and that's a really good way to start.
I accept absolutely all of those points, and what I would say was my understanding when looking at the work that the Chamber Desk had done on my behalf to try and come up with a form of words was that when they were referring to a person who was subject to an order, that was the person protected by it. But I understand from my conversations with the Minister yesterday, and that was the first time I'd heard that. No one proactively got in touch with me. And what I would say is, Mr. Cole-Hamilton's absolutely right that amendments are not usually subject to wholesale consultation at stage 2. And I do find it, as a parliamentarian, unnerving, given how easy I am to contact, given that my details are in the public domain. That if a body like the Scottish Courts and Tribunal Service had very specific concerns about my amendment, they wouldn't choose to share that with me directly and would only communicate with the Scottish Government. And I can understand why they do that given the accountability that's there, but I think in the interest of making good legislation, they should be maybe mindful of working with members. And I've heard certainly what the Minister's said in her comments, and I'm pleased that she's confident that anonymity's already there. But when I look at what the experts have to say, it worries me that the Law Society themselves in the government consultation say, and I quote, "We have concerns that the current statutory provisions may not be adequate to ensure anonymity for all victims of FGM. And they conclude on balance that some provision is needed. I'm going to make a little bit of progress and then I'll come back to Fulton McGregor. I would also highlight the fact that the Equality and Human Rights Commission supports the proposal to provide anonymity to victims of FGM. And indeed, the Minister herself said in a letter to the committee at the start of this process, and indeed, I think it's in the government's consultation analysis, that they're willing to listen to what the committee and Parliament think. And I hope that by passing, albeit a poorly drafted amendment today, the committee would have a chance to demonstrate that it does believe that there should be as close to a right to anonymity as is possible. And yes, there is a better path to doing these things, but in this case, I was happy to accept that with the legal aid amendment. I was happy to accept that we'd had a guarantee put on the record, but I didn't hear in the Minister's remarks today a willingness to engage on this issue, and instead it just appeared to be that they don't support the principle. Yeah.
I hear Mr Mundell's concerns and worries, but would he accept that some of us also have a worry that even for a short period of time between stage 2 and stage 3, that this Parliament has in a bill the ability of perpetrators to apply for anonymity, and the courts have nothing to do with that? I am concerned about the reputation of this place, and the message that that gives out to survivors and to women's groups. There will indeed be opportunities to come back to the issue of anonymity at stage 3. But would you accept that if your amendment is passed today, as it's worded, that it just gives out the wrong message? And we should not, legislation in this place should not be advancing the rights of perpetrators, notwithstanding that I'm sure it would be rectified at stage 3.
So, in response to the point the member makes, this is not we're not passing legislation today. We're amending a bill that's not yet passed, and there is another stage to come. And as I've already acknowledged, it's on the record. The member says it's on the record. It's on the record today that that is absolutely not my intention. We've got it on record from all parties sat on this committee that would be changed at stage 3. My problem is that the better path is not available on this occasion because the government are not supportive of the principle of providing anonymity to victims. They want to leave that decision to be made in the court in each individual circumstance, and I think the balance should be the other way round. I think there should be an expectation, as was in our committee report. I think there should be an expectation up front. Almost a presumption, and that it would go the other way round.
Convener, can I just ask Oliver Mundell to be absolutely clear here that he's happy for that message about perpetrators being protected to be sent from this Parliament? And then the other point is he also happy that this stage 2 stage being used as a pilot scheme to change, legislation across the board? I have some grave concerns about that. I also have grave concerns about the message also that's being sent that in Amendment 23, the courts can be trusted to deliver all of that detailed care package, but they can't be trusted to deliver anonymity for people who are at risk. That seems to be something that can't be rectified here unless Mr Mundell changes position from amendment to amendment, which would make his whole approach completely inconsistent.
So I'll answer the last point first because it's really very simple. It's about the message it sends. They're two different things. One is about the court stepping in to put provisions in place on behalf of the victim, and the other is about the rights of the victim. And I don't see I don't see it as a lack of trust in the court. I see it as being a symbolic statement in the legislation for people, so that they know for sure subject to exceptional circumstances, and exceptional, is a word that's well known to Scottish courts. That subject to exceptional circumstances, they would have that entitlement. And I think it's not about not trusting the courts. I think it's about who the right person is to make that decision. And in this case, I think the right person, when it comes to something as intimate as this, is the person who's affected themselves. I don't think they should have to be going around applying to people to ask for anonymity. And the Minister hasn't answered my point about the concerns of the Law Society. She didn't intervene to clarify what conversation she's had with them about their concerns about current statutory provisions. It just seems to be that we're cherry-picking arguments out, and I absolutely don't accept the point she made at the start. I've said it now 3 times, and I'll say it a 4th. I do not think that perpetrators should have the right to automatic anonymity. I accept that there are some difficulties with the drafting of the amendment, but I think that anonymity for victims is so important in this case, so important, and I so want to see it delivered, and I want the government to work with me. And given the lack of support for the principle that it should be as close to automatic as possible, I want to see this on the bill. And stage 2 is the chance to do that. That's how we get the government to move and to work on making things workable. Because if I withdraw this and come back with another amendment at stage 3, it might be subject to the same technical difficulties. And the advantage of it being in the bill is that I believe the government will be more likely to work with me to fix the concerns. And I don't have a problem with FGM being a pilot for this particular provision. It's actually, in fact, a good opportunity to test out some of the points that Alex Cole-Hamilton's made, because it's likely to apply to a relatively small number of people. And there's plenty of opportunity then to review how it works in practice. But I think we need to do more for victims. We need to make sure that victims are put at the heart of our justice system. And then when it comes to protecting very intimate details about their private life, I think that's a reasonable expectation that should be delivered. Thank you.
Brief
yes,
intervention. And I know I can see that I just want to put on record my absolute grave concern that something leaves our committee that has the potential to give anonymity to perpetrators. Because I suppose thinking about the practical implications of that and thinking about victims, I wonder, for example, does that mean that somebody could be in another jurisdiction and that, their conviction wouldn't show up on a PVG? And I know we're saying that none of the parties, none of the justice spokespeople have ever raised, put forward a case for alleged perpetrators of sexual crime to have anonymity. But when this leaves here, it's open to the rest of the Parliament. That leaves there with that on the bill, and it really, as strongly as you feel about anonymity, and I've got huge sympathy with that and anonymity for victims. I think that point about the perpetrators is really hard to get past, because it's there's a risk there in it leaving.
I think, Convener, with all due respect, there's only a risk if you don't trust that the rest of the Parliament would share the views of the committee. And if you think that anyway, then it would be open to other members of this Parliament to put all sorts of odd and unusual and perverse amendments. And I think in at stage 3, and that there would, theoretically, if you don't think that there's a majority of members to tidy up this amendment at stage 3, then there maybe isn't.
I don't want us to get into too much of a to and fro, but I suppose as you say that to me, I'd reflect that why would you not just come back with a really tight amendment that does exactly what you want it to do and doesn't include that risk in it, if it's open, which it is to everybody, Because
I acknowledged up front at the start of my contribution on this amendment that this is a very complicated area, and I think that it would be better addressed as has been done elsewhere in the UK, with not the same proposal as this, but something different, and is done in other jurisdictions, and already exists through some elements for some. Anonymity does operate in some sense in the Scottish legal system, so it's not like a new concept. But I think that, provided the committee agrees with the principal driver behind this, that there should be a different provision in place for anonymity for FGM, then I think that I would want the drafting help and support of the government, and I think there would be an incentive if it's on the face of the bill and the committee demonstrates its support for this. And I would have, we're hearing about a better path. I would have preferred if the minister had said that she took, took the views on board and was going to come forward with a proposal. But that's not what we've heard. What we've heard is that this is not an area that the minister wants to go into because she doesn't think that FGM should be used as a pilot for this type of right, and I disagree. I take an intervention from Alex Cole-Hamilton briefly.
I'm grateful for the member for giving way. Oliver Mundell makes the point that this is a very complex amendment, and it is. It's a complex area of law and a very sensitive one at that. Does he agree with me that the parliamentary process of passing legislation affords that stage 2 is the point at which principle is established, and that opposition members who may not have had the support of government to bring forward an amendment can get things into the bill as a point of principle? The fact that also this meeting is not in camera, there are people watching this all over the country, and we can state clearly that this is the intent, and that's why, had Oliver Mundell not made those assurances to the committee at the top, I wouldn't have been able to support it had it just been a blanket extension to perpetrators. But I know Oliver, I know his values, and he would never want to do that. But the risk is that if we withdraw this amendment now, because it is such a technical amendment, that at stage 3 it might be beset by other technical difficulties and not make it into the bill at all. And for those of us who support the principle of extended anonymity to victims, that would be something of a defeat, and I think we would have a missed opportunity as a result.
I understand Fulton McGregor also wanted to come into an interest of politeness.
Yeah, and thanks, Convener. I thought you'd, thanks to Oliver Mundell, I thought you'd forgotten me. It's actually following on from Alex Cole-Hamilton's point. I suppose I think what you're what you're saying here is that you're recognising there's 2 risks. I think you've very very bravely recognised that there's a risk in your motion, and I think you accept that, and you don't want it to pass at stage 3. That this amendment could lead to perpetrators getting anonymity, and I know that that's not your intention. But I have got grave concerns about putting it on the bill. That's weighed against your risk that you don't think the government will come and go with you if you don't put it on at stage 3. And what I suppose I'm asking you, and I suppose not a direct question to other members that might be thinking about supporting it, but even just to maybe think in their head is, which one of those 2 is the most important? Because for me, I can't even believe we're talking about it. It's an absolute no-brainer. We can't put it on something that could lead to, I mean, we could well get to stage 3 and something could pass, that this Parliament passes an act that a perpetrator potentially could seek anonymity. And I don't think, I think that out of 2 of those risks, which one's most important?
So, I mean, in very simple answer to Fulton McGregor's point, I mean, doing some basic arithmetic of everyone in the Scottish Government plus the opposition members of the committee who are here today supported an amendment, I think that would be enough to ensure that could be taken off the face of the bill, and I'm happy to give that commitment. I will take a intervention briefly.
Yeah, I think we're probably coming to the end, but absolutely.
Oh, thank you, Oliver. But I mean, this is a democratic institution. If at stage 3 Parliament makes a decision, regardless of how bizarre that decision is, that would be the will of this Parliament. And we talk about risk. I think that this is a Parliament made up of political parties, all who have expressed a view around this table, and I know I speak for my party when we say we don't want to see a blanket anonymity to perpetrators. I think that's true of every party around this table. But were we made up of parties that did have policy to extend anonymity to perpetrators, that would be the democratic will of this Parliament. I don't think we talk about the risks of handing this over to the wider full Parliament for further amendment at stage 3. That isn't a risk. That is an opportunity to improve and enhance and polish a piece of legislation. And that's why the process of legislation is as it is.
I thank the member for that intervention, and I think I've already said everything I have to say. This is not about perpetrators, it's about victims, and I hope members will feel able to support that principle and use the parliamentary processes available to make sure that is what comes out when the final bill is passed into legislation and becomes the law of this country. Thank you.
Press or...
Press, sorry.
Okay. The question is that Amendment 25 be agreed to. Are we all agreed?
Yes.
Okay, we're not all agreed. Can I ask those in favour of Amendment 25 to indicate their support? And those against? And there are no abstentions. There are 4 members for Amendment 25, 3 members against. Amendment 25 is carried. I call Amendment 2 in the name of the Minister, already debated with Amendment 1. Minister to move formally, please.
All right, okay, I thought it was Group 5. Is that?
We'll suspend briefly while we just check that for you. Okay, thank you. Welcome back. I call Amendment 2 in the name of the Minister, already debated with Amendment 1. Minister to move formally, please.
Moved, Convener.
Thank you. The question is that Amendment 2 be agreed to. Are we all agreed? Agreed. I call Amendment 3 in the name of the Minister, already debated with Amendment 1. Minister to move formally, please.
Moved, Convener.
The question is that Amendment 3 be agreed to. Are we all agreed? Amendment 3 is agreed. I call Amendment 4 in the name of the Minister, grouped with Amendments 16 and 17. Minister to move Amendment 4 and speak to all amendments in the group, please.
Thank you very much, Convener. You threw me a bit there, but we're now back on track. These are, again, minor technical amendments to tidy up the bill in relation to Amendments 16 and 17. These make amendments to Section 5M of the bill. This is the section which requires the court to advise the police and the relevant local authority that a matter relating to an FGM protection order is being dealt with by the court. Where an application to vary or discharge of FGM protection order is made under Section 5J1, the bill sets out that the court's decision under Section 5J1 is notified. Amendment 16 clarifies that where the court makes such a decision without having received an application, then that type of decision is also notified. Amendment 17 makes a similar amendment to the bill provisions in the case of a decision to extend an FGM protection order, and I move Amendment 4.
Thank you. Do any members wish to contribute? No. Okay, Minister, do you need to wind up? Or?
I think it speaks for itself, really.
Okay,
thank you, Convener.
The question is that Amendment 4 be agreed to. Are we all agreed? Amendment 4 is agreed to. I call Amendment 5 in the name of the Minister, grouped with Amendments 6 and 7. Minister to move Amendment 5 and speak to all amendments in the group, please.
Yeah. Convener, following the introduction of the bill, my officials have taken forward further discussions with the Scottish Courts and Tribunal Service on the workings of FGM protection orders. Section 5G provides criminal courts with the power to make FGM protection orders on sentencing relative to FGM criminal conviction. The bill then provides that an FGM protection order made under Section 5G was to be treated as if it was made in civil proceedings for all purposes thereafter. We did this because FGM protection orders are designed to be living orders so that they can be varied and extended and have parts discharged as a protective need for the person, the protected person, and maybe changes. For example, an FGM protection order banning foreign travel, for instance, where it may be varied for a family holiday, where the details of which pose no threat to that girl in question. In such cases, we deliberately provided that such changes would be made through the civil courts, even if the order was granted by a criminal court. This is both to avoid criminalisation of the process as far as is possible, and also because the sheriff or summary sheriff is a far more accessible forum than the High Court, which is the court most likely to be dealing with an FGM criminal offence. However, in transferring all aspects to the civil court, this meant that if the convicted person were to appeal against the making of the order, then that would also be treated as a matter for the civil courts. This could have the effect that there would be one appeal appeal in the civil courts against the order, but another separate appeal against the criminal conviction or sentence in the criminal court. Such twin appeals bring with it the potential for confusion and increased cost to the system and possible conflict between competing court judgments. As this result was unintended, we have put forward these amendments to ensure that orders granted by a criminal court under Section 5G for an FGM conviction can, for the purposes of appeal by the convicted person or the Crown, go through the criminal court system along with the rest of the sentence. Such appeals will not involve the protected person, nor will they involve other family members. For the reasons I've set out above, on accessibility and the need to avoid criminalising the process, there is, however, no change to the treatment of applications for variation, discharge or extension of such an order, which will remain within the civil system. And I hope that remedies an issue that we all thought about at stage 1, and I move Amendment 5.
Thank you, Minister. No members are indicating they wish to speak. Minister, assume you don't need to wind up.
Again, it speaks for itself, Convener.
Thank you. The question is that Amendment 5 be agreed to. Are we all agreed? Agreed. Amendment 5 is agreed. I call Amendment 6 in the name of the Minister, already debated with Amendment 5. Minister, to move formally, please.
Moved formally.
The question is that Amendment 6 be agreed to. Are we all agreed? Agreed. Agreed. Amendment 6 is agreed. I call Amendment 7 in the name of the Minister, already debated with Amendment 5. Minister, to move formally, please.
Moved.
The question is that Amendment 7 be agreed to. Are we all agreed? Agreed. Amendment 7 is agreed. I call Amendment 8 in the name of the Minister, grouped with Amendments 9, 10 and 11. Minister, to move Amendment 8 and speak to all amendments in the group, please.
Again, thank you, Convener. These amendments, again, are technical in nature. They clarify the bill provisions in two situations. Firstly, relating to an FGM protection order where its period of effect has been varied, and secondly, where the FGM protection order as originally made did not specify a period for which it was to have effect, but is then subsequently varied to specify a specific period. Amendments 8 to 10 will put beyond doubt that where an order only has one time period that relates to a condition, together with another condition which is not subject to a time period, that the other remains in effect until the order is discharged. Amendment 11 clarifies the way in which the provisions in the bill will relate to the duration of the FGM protection order and interact with FGM protection order 2 when it is varied, extended or discharged. And I move Amendment 8 in my name.
Thank you. No members wish to contribute. Minister, content that I move to the
content
vote?
to
Okay.
carry on, yeah.
The question is that Amendment 8 be agreed to. Are we all agreed?
Yes. Agreed.
Amendment 8 is agreed. I call Amendments 9 to 11, all in the name of the Minister and all previously debated with Amendment 8. Minister, to move Amendments 9 to 11 on block.
Happy to move on block.
Thank you. Does any member object to a single question being put on Amendments 9 to 11?
Yep.
Okay. The question is that Amendments 9 to 11 are agreed. Are we all agreed?
Agreed.
Amendments 9 to 11 are agreed. I call Amendment 12 in the name of the Minister, grouped with Amendments 13, 14 and 15. Minister, to move Amendment 12 and speak to all amendments in the group, please.
Thanks, Convener. Amendments 12 to 15 are again technical in nature. Section 5A4 and 5 of the bill requires the court to take into account the views of the person who will be the protected person when making an FGM protection order. Section 5L of the bill makes clear that that process must also be gone through by the court when considering whether to vary, extend or discharge an FGM protection order, or when considering whether to vary or extend an interim FGM protection order. Amendments 12, 13 and 15 tweak the language of the bill to ensure any reference to a person who would be protected is read as including a reference to a person who is protected already when the court considers the variation, extension or discharge of an FGM protection order. Amendment 14 does the same when the court is considering the variation of or extension of an interim FGM protection order, and I move Amendment 12.
Thank you. No members wish to contribute. The question is that Amendment 12 be agreed to. Are we all agreed? Amendment 12 is agreed to. I call Amendments 13 to 18, all in the name of the Minister and all previously debated, and I invite the Minister to move Amendments 13 to 18 on block.
Moved on block.
Thank you. Does any member object to a single question being put on Amendments 13 to 18? No. The question is that Amendments 13 to 18 are agreed. Are we all agreed? Agreed. Amendments 13 to 18 are agreed to. The question is that section 1 be agreed to. Are we all agreed? Agreed. Section 1 is agreed to. The question is that sections 2 to 7 be agreed to. Are we all agreed? Sections 2 to 7 are agreed to. I call Amendment 19 in the name of the Minister, grouped with Amendments 20 and 21. Minister, to move Amendment 19 and speak to all amendments in the group, please.
Thanks, Convener. The bill at Section 8 already amends the Children's Hearing Scotland Act 2011 to enable the court to refer a matter to the principal reporter if it thinks a ground for referral has arisen in the course of consideration of an FGM protection order. Amendments 19 to 21 extend that power to include cases where the FGM protection order is varied, discharged or extended by the court of its own volition, bringing that into line with the court's powers in cases where a variation, extension or discharge has occurred by way of an application. The amendments put beyond doubt that the courts can, if they think a ground for referral has arisen, to be able to refer the matter to the principal reporter whenever the circumstances of an FGM protection order have changed. And I think it addresses an issue that was raised at stage 1 to Convener. And I move Amendment 19 in my name.
Thank you, Minister. No members wish to contribute, and if the Minister is content to move on, I'll put the question. The question is that Amendment 19 be agreed to. Are we all agreed? Agreed. Amendment 19 is agreed to. I call Amendment 20 in the name of the Minister, already debated with Amendment 19. Minister, to move formally, please.
Moved.
Thank you. The question is that Amendment 20 be agreed to. Are we all agreed? Agreed. Amendment 20 is agreed to. I call Amendment 21 in the name of the Minister, already debated with Amendment 19. Minister, to move formally, please.
Moved.
Thank you. The question is that Amendment 21 be agreed to. Are we all agreed? Agreed. Amendment 21 is agreed to. The question is that Section 8 be agreed to. Are we all agreed? Agreed. Agreed. Section 8 is agreed to. I call Amendment 22 in the name of the Minister in a group of its own. Minister, to move and speak to Amendment 22, please.
Yeah, thanks again, Convener. Amendment 22 adds FGM protection orders and interim FGM protection orders to the list of civil proceedings set out in the Courts Reform Scotland Act 2014, for which the summary sheriff has competence. Summary sheriffs were introduced by the 2014 Act as part of the wide-ranging reforms to the courts recommended by former Lord President Lord Gill. One of the key aims of the reform of the court system was to bring justice as close to the public as possible with the introduction of a third tier of the judiciary. Empowering summary sheriffs in this way does not remove the powers of the sheriff for these cases. However, it does mean that the sheriff principal for a sheriffdom will be able to move quickly and flexibly in deploying the full range of judiciary to deal with matters relating to an FGM order and an interim FGM protection order. This amendment brings the treatment of FGM protection orders into line with the civil court's treatment of forced marriage protection orders and proceedings relating to domestic abuse, adoption, children's hearings and family law, all of which can be dealt with the summary sheriff, and just allows another avenue of justice for the public. I move Amendment 22.
Thank you. And no members are indicating they wish to speak. If the Minister is content, I'll put the question. The question is that Amendment 22 be agreed to. Are we all agreed? Agreed. Amendment 22 is agreed to. The question is that sections 9 to 11 be agreed to. Are we all agreed? Agreed. Sections 9 to 11 are agreed to. The question is that the long title be agreed to. Are we all agreed? Agreed. That ends consideration of Stage 2, consideration of the bill. The bill will now be reprinted as amended at Stage 2 and will be published at 8:30 a.m. tomorrow. Stage 3 amendments can then be lodged with the clerks and the legislation team at any time. The Parliament is not yet determined when Stage 3 will be. When this is confirmed, members will be advised of the deadline for lodging Stage 3 amendments. Can I thank the Minister and her officials for their attendance. The committee will next meet on Thursday the 6th of February when it will consider its approach to race equality, employment and skills inquiry. I close the meeting.